Good afternoon, everybody. Thanks for joining us for another webinar presentation in Count Maciel Carey's 2022 OSHA webinar series. We are into February, and I ordinarily would say this is our second program of the year, but I'm pretty sure we've had multiple emergency sessions over the course of just the first month and a quarter of the year, as has been the case for the last couple of years. Hopefully we're winding down that, and hopefully this is the last really significant sort of COVID-19 focused presentation we do in the webinar series, but I've been hopeful of that for quite a few months now, and alas, here we are. Today's program is a review of the rulemaking and enforcement landscape about COVID-19 post-Supreme Court, after the Supreme Court's decision back in January, essentially striking down OSHA's vaccination, testing, and face coverings, ETS. And I was really hopeful, a lot of things that I've been hopeful about, I was really hopeful that by today we'd have a really clear understanding of OSHA's expectations for employers in a world after the Supreme Court decision, in a world after the vaccination and testing rule has been withdrawn. But we don't have a lot of great answers. So what we're going to do today is go through a little bit of the history to where we are now and share the sort of insights of 4, maybe 5, who I think really talented OSHA lawyers, to give you a sense of what we think the lay of the land is now, but also to give you a good view of what a complicated question that is. What is expected of employers today on the COVID-19 front? That you've got folks who have been living and breathing this issue on the rulemaking side, on the enforcement side, on the policy side for 2 years now, not able to give a real slam dunk answer on what's expected of you today. And that answer may be different today than it is tomorrow. It may be different in one part of the country than it is another, but that's the idea. That's what we think is the important questions we're getting every day from our clients, the important water cooler discussions we're having with each other every day. And we thought we would just pull you into that sort of water cooler discussion. So let's—
chaos.
What's that?
Chaos.
Yes, exactly. No, there's order to this. There's a great deal of order to this. Very quickly, some brief introductions. We know, most of you and have known you for a long time, but just a real quick a sense of who's presenting today. I'm Eric Kahn. I'm one of the founding partners of Kahn Maciel Carey, and I chair the firm's national OSHA practice group. I've practiced in this field now exclusively for 22 years, including the first decade or so, alongside the former first general counsel of the OSHA Review Commission. I have had the pleasure, I suppose I'd call it that, of co-chairing our firm's COVID-19 task force, to be the OSHA co-chair of the task force over the last couple of years. So we've dug deep into all this, and hopefully our insights are valuable to everybody. I'm pleased to be joined by several of my partners today who have also been steeped in the COVID-19 issues over the last couple of years. Kate Mcmahon. Kate, you want to say hello?
Hi, everyone. Nice to talk to you today. I hope that the discussion we have today has some value to you and brings some insight into the way we've been thinking about what to do next, really. We'll review what we're going to do, but we're going to really talk about what to do next. And we've, my background, I think, is known by many of you. I've been working in this area for, as Eric says, he's not going to explain how many years because it would give away my age, but longer than some have been even out of law school, I'm sure. So anyway, it's good to be here with you and good to focus, even though we're dealing with COVID and I'm hoping it's soon in the rearview mirror. We're dealing with health standards, which is one of my favorite areas and one that I think I have some expertise in. So I look forward to talking to you today.
Aaron?
Hi, everyone. My name is Aaron Gelb. I lead the firm's Midwest OSHA practice. I still will admit how long I've been practicing, I guess, although I now get associates who tell me that they were born after I graduated law school. So there is always that. So I'll turn it over to Amanda to introduce herself.
Hi, my name is Amanda Stranis-Walker, and I'm happy to be here with my colleagues today and share a little bit of the background discussions that we always have offline, trying to figure out what the next, where OSHA is going, what the CDC is saying, and talking about COVID, which has been a topic of discussion for the past 2 years that we've all learned a lot about.
And I think our colleague Bita Lashkari has joined us as well. I don't have a bio slide for her, but Bita, you want to say hello?
Sure. Hi, everyone. My name is Bita. I'm the associate on this call today. I work closely with Kate, Aaron, Eric, and Amanda for the last 2 years, mostly on COVID-19. Happy to be here with you all.
Yeah, Bita has an encyclopedic knowledge of what every state is doing, what the latest guidance says. So we thought for our kind of open forum discussion at the end, it would be real helpful to have Bita join us as well. So here's what we're going to talk about today. I sort of set the stage already. We're going to get a little bit of the history of sort of how we got here, how we got to this moment in the pandemic from a regulatory and enforcement standpoint, which includes, really the focus on what's happened during the Biden administration, because we think that's more instructive of what we can expect from OSHA going forward. And then, what happened with the most recent rulemaking, what the agency has said and done since the Supreme Court took the action that it took back in January. And then we're just going to have a sort of a free-flowing discussion about what we think all of this means for employers today. Now I'm going to hand it over to Aaron to kick off the discussion.
Thanks, Eric. I always enjoy taking a stroll down memory lane, although I think as we enter year 2, it sometimes becomes a challenge to remember what happened when and under which administration, since the pandemic spans 2 administrations. But just to recap and set the context for everyone who's listening today, as far as how we got here under the current administration. So we're just into the beginning of the second year of the Biden administration, and we think back to the inauguration and day one. As I'm sure if you joined us for past webinars, you hear us kind of wax poetic about how much it meant to us to have the president talk about our little niche practice area and mention OSHA in an executive order on day one. In that order, as you all may remember, there were a number of directives to the agency that included developing and launching a national emphasis program focusing on COVID, to consider, evaluate whether an emergency temporary standard was necessary, and if so, remember thinking back to before all the drama over the past few months, to issue that standard originally in the spring. I think it was by March or April of 2021. And what ended up happening, in addition to that, the president reinvigorated the COVID-19 task force, staffing it up, kind of obviously removing some of the folks from the prior administration, replacing them with a number of public health experts. And then, although OSHA missed the deadline, we were all kind of sitting and waiting on pins and needles. What's the agency going to do? Are they going to issue a broad rule that applies to general industry? If so, what's that rule going to look like? That initial deadline that was set by the president came and went. And as you all may remember, we end up, I think many of us were surprised, with a healthcare only rule that issued in June of last year. And that, again, rule limited to the healthcare industry. We later found out, obviously, that OSHA had also crafted and sent over to the White House a broader general industry rule that did not see the light of day other than through a FOIA request. And is again, thinking back to where we were in the late spring, early summer of last year, as the CDC had changed its masking guidance, and things appeared to be looking up. OSHA obviously made what I assume is in large part a political decision, or at least it should say the administration made a political decision not to proceed with the general industry rule. Then later that summer, I think around August 13th, OSHA issued updated guidance for non-healthcare workplaces. And some of that, it was a bit of a prelude to the standard and what we saw then take place in the fall and into the winter. There were about 11 points in that guidance. The first one was to facilitate vaccination. Obviously, the administration has really gone all in on vaccination. There were other directives or recommendations in there with respect to isolation and guidance, face coverings for employees, face coverings for third parties, customers, guests, visitors, et cetera. And then kind of many of your standard controls or practices. So education and training for the workforce, routine cleaning. So we saw a retreat from that heavy emphasis on frequent cleaning and disinfection. And then references to obviously record keeping and reporting, kind of the standard prohibition of retaliation. So employees feel comfortable coming forward with concerns or suggestions regarding measures in the workplace. And also, I think we kind of go back and forth, and I think we're going to talk a little bit about this later. There was a recommendation with respect to distancing for unvaccinated and at-risk workers. And as again, this was kind of as we were now seeing the Delta variant rise at the time. And so we're kind of whipsawing back and forth between masks for everyone, masks for the vaccinated, the unvaccinated, et cetera. And so that was the guidance that we saw in August of last year. And I think one of the things that Eric was referencing a few minutes ago is that we had, I think, expected or would have predicted that OSHA might have issued updated guidance once the Supreme Court essentially killed the Vaccinate-or-Test ETS. So we have not seen that. And I don't know if and when we're going to see that. So again, consistent with the administration's focus on vaccination, including in OSHA's guidance from August, then on September 9th, the president announced his path out of the pandemic action plan, which included, I think it was 6 primary steps, one of which is directed OSHA to issue a vaccination ETS, which it did, published that on November 5th of last year. Still seems like yesterday, I think. And then, that really kind of set us off on a pretty wild and bumpy ride. So then if we move to the next slide, just to recap briefly the legal challenges. So obviously, because the administration had announced its intention to issue this rule, those folks that objected to the rule or planned to object to it, but before they saw it, had their arguments at the ready. And within hours, if not the next day, I think it was by the 6th, that the Fifth Circuit had issued a temporary stay of the rule. And then that stay was made more permanent on on November 12th. And then because there were so many challenges filed by so many different groups in all the federal circuits, pursuant to the rules in such situations, those cases a lottery was held, and those cases were all consolidated in the Sixth Circuit. There were obviously lots of predictions that the Sixth Circuit, given the makeup of that circuit, that the rule was likely to remain stayed and never see the light of day again. I think much to our surprise, and a number of us were actually together the evening of December 17th, when we received notice at the Sixth Circuit, much to, I think, everybody's surprise, that a 3-judge panel had lifted the stay. That then kicked off a whole set of, I think, a lot of panicked phone calls and emails from folks that realized, okay, I guess we're going to have a policy and begin complying. And so there was lots of that work that began, and then the case was taken up by the Supreme Court, as everyone now knows. Oral arguments were heard on January 7th of this year. And then just under a week later, the Supreme Court issued the decision that Eric will now recount and analyze for you all.
Thanks, Aaron. Yeah, and we've talked about the Supreme Court decision a little bit. If you've joined any of our other recent webinars, I'll just go through it briefly. We've written about it, and you may have even heard us talk about it a little bit, but it was a big deal, right? In my 22 years of practice in this field, I'm pretty sure it was the first time the word OSHA was said at the Supreme Court. So it bears talking about again, and I think it's really an important piece of the what happens next discussion is what the Supreme Court decided, the basis for the decision. But the decision, as I'm sure you all know, was to reinstitute a nationwide stay of OSHA's emergency standard. It was a 6-3 decision. with 3 judges signing on to not signing on. It was a per curiam opinion, means an opinion of the court without their names identified, but by the process of elimination, we know that the 3 judges that were 3 justices that were involved in the per curiam decision were Justice Roberts, Justice Kavanaugh, and Justice Coney Barrett, who have become sort of something of a swing, the swing justices now on a fairly conservative Supreme Court. There was a concurring opinion with 3 justices signing on to the opinion. I think it was written by Justice Gorsuch and signed on to by Justices Alito and Thomas. But as a concurring opinion, that means those 6 joined, at least in the decision to stay the ETS, although they had slightly different, how far they would go in the basis for why that rule would not go into effect. And then you had a joint dissenting opinion from the 3 liberal justices on the bench, Justices Breyer, Kagan, and Sotomayor. Technically, the case was before the Supreme Court only on the question of whether the vaccination ETS should be stayed pending the more complete merits determination that was still pending before the Sixth Circuit. And that was what the decision was, whether to stay the ETS. But in evaluating whether a temporary restraining order should issue, one of the major questions that has to be asked and addressed by the court is whether the legal challenge to the rule, in this case, the legal challenges by the states, brought by the state attorneys general and some private employers and other groups, whether those legal challenges were likely to be successful on the merits. So the Supreme Court's decision, both the per curiam decision and the concurring opinion, really dove into the merits in a way that left no doubt as to what the court's feelings were about the merits of the challenge to the ETS. And so even though it was technically just a temporary restraining order, there was a pretty strong signal, I think, by the Supreme Court to the Sixth Circuit to say, here's what we think ought to happen, Sixth Circuit, but even more of a strong signal to say, no matter what the Sixth Circuit does, it's going to come back to us before the rule is allowed to go back into effect. And we're telling you, OSHA, what our intentions are if this rule comes back to us. So what is it that the Supreme Court decided, or why did the Supreme Court decide that there was a high likelihood of success on the merits of the legal challenges to the rule? In other words, a high likelihood that the court would find that the rule was an unlawful exercise of OSHA's authority. What the Supreme Court said was that the case was not about how to respond to the pandemic. The evaluation of the emergency temporary standard and vaccination-related regulation was not about how best to respond to the pandemic. And that may well be the best and most effective way for OSHA to regulate the COVID-19 pandemic hazard. But the question was really, who holds the power to address the pandemic hazard or to address it by way of a vaccination-related regulation? And what the court said was, by law, that power rests with the states and with the United States Congress, not with OSHA. And so what they were really trying to say was that if OSHA is going to issue lawfully a rule that regulates vaccination and addresses this COVID-19 hazard that is broadly applicable and exposes all of us in our daily lives, not just in the workplace, but if OSHA is going to lawfully regulate that issue in this way, there needs to be a more explicit delegation of authority from Congress for OSHA to be allowed to do that. And the concept was that there are some issues of such exceptional political and economic consequence that the courts have to presume that Congress did not intend to delegate those exceptionally important issues to an executive agency unless the delegating statute is very clear. And this is what is known now as the major questions doctrine. Although interestingly, the per curiam opinion, that quote, talking about those issues of such exceptional political and economic consequence and requiring specific, more clear delegations to address those exceptionally important issues, doesn't use the word major questions doctrine, but it has defined what is commonly understood to be the major questions doctrine. So that is the basis for six Supreme Court justices agreeing, at least on that issue, that this issue of addressing a pandemic and addressing it by way of a vaccination requirement was a major question. And a major question is one that should not be addressed by an executive agency. Instead, it should be addressed by Congress. And so Congress could either pass a law that requires vaccination or testing in workplaces, or by some form of legislation dictate to OSHA that it shall promulgate a rule that does that. And it hadn't done that. Instead, OSHA was relying on its authority in the now 52-year-old Occupational Safety and Health Act of 1970, and that statute, the Occupational Safety and Health Act, does not clearly enough delegate authority to OSHA to issue a regulation for something that these six Republican justices determined was not unique to the workplace and was so fundamental. And what they viewed to be such a fundamental question was ordering, and this is a quote from the concurring opinion, ordering 84 million Americans to either get a COVID-19 vaccine or to undergo weekly medical testing. And there were some references in the opinion to say, at the time, thinking back, and this was only a month ago, but it's, you got to remember where we were. At the time that the Supreme Court was hearing argument on this, testing was really hard to come by. So there was some reference in the opinion and some reference in the oral argument to the idea that while there is this testing out option, if tests really aren't available, this really does just become a vaccine requirement. And that's a fundamental question. And we're not saying that it's not appropriate. We're not saying that it's not the most effective way to address the hazard. We're saying it's so fundamental that Congress should be the one that decides, because Congress is accountable to the people, whereas an executive agency is less so, although it is somewhat accountable because it's the administration's executive agency and they are accountable. But that was where the Supreme Court went. And ultimately, and this was, I thought, a pretty meaningful quote from, I think, also the concurring opinion, that permitting OSHA to regulate the hazards of daily life simply because most Americans have jobs and face those same risks that they face in daily life while on the clock at work, that would significantly expand OSHA's regulatory authority without clear congressional authorization. So that is the Supreme Court effectively striking down OSHA's authority to regulate the COVID-19 hazard, at least with respect to doing it by way of a vaccination requirement. There were some references in the opinions, in particular the concurring opinion, which is important because those justices could realign with the liberal justices on this issue, the issue that there are some industries perhaps where the exposure to COVID-19 in the workplace is truly a unique workplace exposure. And the justices in oral argument and in the opinion talked about how in healthcare or in laboratories that do research with active COVID virus, or workplaces where there is such a dense and close quarters and densely populated workplaces, that those may be more of a unique workplace risk than most workplaces in the country, where employees' exposure to the virus is not so different than the exposure that we all experience everywhere and anywhere we go in our daily lives. So the idea being that there may be a regulation that could be fashioned, even one that relates to vaccination, that might be acceptable to a majority of this Supreme Court, but a broad, sort of all industry covered, broad vaccination related rule is just not something that OSHA has authority to do. And importantly, this was not a decision about OSHA's emergency rulemaking authority. This was a statement about OSHA's authority under the OSHA Act, period. And one thing that's really important that we'll talk about a fair amount, I think, the rest of the day today, is that while this decision was about OSHA's rulemaking authority, really what they're saying is that the OSHA Act itself is not clearly enough, does not delegate more clearly enough to OSHA the authority to address this hazard. And so to me, regulation, rulemaking, and enforcement are two sides of the same coin. So if the Supreme Court is saying, OSHA, you don't have authority to write a rule that addresses this hazard, it strikes me that the same message is being sent that OSHA may not have the authority to enforce this by any mechanism, right? By their general duty clause, perhaps even by specific regulations that relate to respiratory hazards, that this particular respiratory hazard might be one that OSHA just doesn't have authority to address outside of healthcare and outside of some of these other industries that OSHA identified. Real quickly, what did this mean for the state plans? Well, remember, when OSHA issues an emergency standard, the state plans that operate with federal OSHA's authority are required to adopt a substantially similar or to adopt an as effective regulation. So when OSHA issued the rule, the state plans were required to adopt some form of vaccination testing and face coverings emergency standard. They could go beyond, they could do a hard vaccine mandate, or they could adopt an identical rule. They were required to do that. When the Supreme Court basically struck down federal OSHA's rule, the requirement for the state plans to adopt a vaccination rule went away, right? Because their duty to do so was only so long as federal OSHA had such a rule. Federal OSHA no longer had that rule, so the states were not obliged to adopt that rule. But the Supreme Court's decision, again, we just talked about, was based on the United States Congress delegation of authority to federal OSHA. So it did not prohibit, the Supreme Court did not bar state plans from adopting a vaccination rule because the state plans get their authority from a different source. It doesn't come from the United States Congress. It comes from some enabling statute in that state. And so there may be a state court, Supreme Court decision that would have come along and said, state agencies, you don't have this authority either. But the point being that by virtue of the January, whatever it was, January 13th decision from the Supreme Court, that didn't bar the state plans from adopting a rule. So what are they going to do? I think the answer is pretty clear now. This is one thing that I do think we have pretty good information on at this point. It's pretty safe to say that none of the state plans are going to adopt a vaccination or testing rule of any kind in those states. The one state that had already adopted a verbatim adoption of federal OSHA's vaccine ETS was Minnesota OSHA. It adopted on January 3rd. And by January 14th, the day after the Supreme Court decision, Minnesota OSHA announced that it was withdrawing that rule. The state of Illinois had adopted the same rule, the identical federal rule for public employees. Similarly, on January 14th, it withdrew that rule. Other states that had a rulemaking item on the agenda to adopt either an identical or some form of vaccination rule like Cal OSHA was set to vote on that on January 20th, and they were going to vote on what they called a Horcher motion, which in California allowed California OSHA to adopt without any real rulemaking process at all, to adopt a Fed OSHA rule essentially as is. That was on the agenda to be voted on January 20th. All indications were it was going to be approved. On January 14th, Cal OSHA withdrew that item from the agenda. Oregon OSHA, Washington OSHA, Michigan OSHA all did the same thing, signaling clearly after the Supreme Court decision that they were not moving ahead with a state version of the rule. So that means there is not a vaccination or testing emergency rule likely to occur anywhere in the country, except, and Kate is going to talk a little bit about what federal OSHA is doing now in the wake of the Supreme Court decision.
All right. Well, we spent just about half an hour talking to you about what has happened so far. And what we want to do now for the rest of the webinar is talk about where we go from here. And it was an important backdrop. We didn't do this just to, make you live through the nightmare of what we've all experienced the last 2 years, both in terms of COVID, but also in terms of OSHA's regulation and enforcement of its COVID policies and regs and emergency standards. It was because it sets an important backdrop and I think guardrails on what we can expect to see going forward. COVID, as we know, is here. I'm not going to say to stay. It's changing rapidly. It's getting much, much better very quickly. But it does not look like it is going to be eradicated anytime in the near term. And the agency, I think, feels a responsibility to address that hazard in the workplace to the extent it can, based on what Eric just described and what we know from what Aaron described already is sort of its predilection in terms of control of this hazard. So where do we go from here? The first signal we had after the Supreme Court's decision, in fact, that very evening of the Supreme Court's decision, the Secretary of Labor, Marty Walsh, issued a statement, and we have the pertinent quotes from the statement on the screen right now on our slide. What I think the message the agency, the Department of Labor, was sending to employers across America and employees was a couple of things, twofold essentially. One, we got beat by the Supreme Court, but employers, you can do this voluntarily. You don't need a rule to require your workers to be vaccinated and or make those who won't get vaccinated tested. Do it voluntarily. That was the first message, encouraging employers to take that rule that had been developed and implement it anyway. Second point, following very quickly on the first one, is remember, we have enforcement authority. We have the COVID National Emphasis Program that is already on the books, and we have the very powerful General Duty Clause. So employers, remember, we as an agency have a responsibility to make sure you as employers are accountable for the hazard in the workplace, regardless of what the Supreme Court just said. So that was the first message out of the box from Secretary Walsh. But what's happened since, and what do we think is going to happen? Okay, so couple of benchmarks or important points to keep in mind. One, there is still, as I said, on the books, the National Emphasis Program. OSHA put that, issued the National Emphasis Program 2 months after President Biden was inaugurated in March 2021. They revised it in July of 2021 and actually narrowed pretty considerably the number of targeted industries, but it still exists. And so signal number 2, for those industries who are still covered on the National Emphasis Program, beware that OSHA's focus in terms of the COVID hazard is on your industries. Those industries include mainly healthcare and sort of ancillary industries surrounding healthcare, dentist's office, home healthcare, nursing homes, long-term care facilities, ambulatory services. So healthcare industry generally, and also some non-healthcare industries. The poster child now for, the high hazard COVID industry, the meat packing and poultry processing industries are still there. Grocery stores are still there. Warehousing is still there. Postal service is still there. And restaurants are still there. So there may be a couple of others, but those are the main industries. So one, those industries still need to be very focused on protecting their workers from COVID hazard. And we'll talk about whether OSHA can do that, can give itself more, a greater arsenal to enforce in those industries by establishing a rule that actually targets those industries specifically on top of the National Emphasis Program. Second thing is another sort of signal as to what's going to happen. OSHA has not pulled the COVID workplace guidance from the website. It's still there. That COVID guidance that was promulgated first, in the early days of the Biden administration, actually might have even, Bita's my knower of all dates. So I can't remember.
Yep, I think January 29th, Kate.
Okay, thank you. So January 29th, a week after Biden becomes president, this guidance goes up live, and this is the programmatic guidance, the stuff that Aaron was talking about, barriers, distancing, plans, isolation, the whole gamut of activities, actions, programs, and steps that employers according to OSHA, ought to have in place to control this workplace hazard. All right, so what do we do? Well, what else is there? There's the general duty clause, as I mentioned. That general duty clause can be used to enforce the COVID guidance. And by the way, not only is there the OSHA guidance, but that corresponds with and aligns with CDC guidance, which to our mind has become even more important than the workplace guidance that OSHA has issued. Basically, what the CDC said is now the guidance that we think, to the extent there's going to be enforcement under the general duty clause, will be the guidance underlying that enforcement. So the CDC guidance still exists. And then finally, rulemaking. OSHA has, rulemaking authority. And so what are we likely to see in the way of rules? Okay, so we know that the Supreme Court basically, as Eric so aptly described, struck down, procedurally, it was only the stay, it issued a stay, so theoretically the rule could go on, but OSHA saw the writing on the wall. The decision was very clear and very broad. So the agency decided to end the ETS, to withdraw the ETS. And they did that on the 25th of January, shortly after the Supreme Court made their decision. Interestingly, and as our slide says, that was expected. We did not expect the agency to fight this futile battle, to continue to, fight the good fight, as they would say, to put an ETS in place. So that's gone. But remember that the ETS by law serves as the proposal for a permanent rule on that in that area, right? So that ETS, the Vaccine-or-Test and face mask ETS, is the proposed rule that exists. What surprised us somewhat is that OSHA, when they withdrew the ETS, they actually announced that they were going to move forward with the rulemaking. They said they were going to do it expeditiously in 6 to 9 months. They expected to have a permanent COVID vaccine or test and face mask rule on the books. But also interestingly, if you look at the notice that they issued, they said the agency is prioritizing its resources to focus on finalizing a permanent COVID-19 healthcare standard. So even though the general industry applies to everyone, proposed rule remains in the works towards a final rule, OSHA has also said to us, they're gonna, for now anyway, prioritize healthcare. Okay, so, I think we wanna kind of wrap up and start talking about what we really suspect is gonna happen here and I'm gonna open it up to my colleagues, but just wanna make a couple of additional points. Remember, as Eric said, the Supreme Court's decision was not based on the emergency rulemaking. It was based on the court's view that OSHA did not have authority in general to regulate COVID. However, it was very clear, again, as Eric said, that we had a number of justices who thought that there might be that OSHA may have authority to regulate COVID for certain workplaces. So what do we expect from a permanent rulemaking? There could be a number of things that could happen here. One, we know the healthcare proposed permanent rule is going forward. We know the agency has been sued over that. We know from the agency's own mouth that they're prioritizing establishing a COVID rule for healthcare. That COVID rule for healthcare will look like the programmatic standard that existed as an ETS. But one question is, will it also have some components of the Vax-or-Test standard? That is, will OSHA pull over the vaccine and/or test requirement into a permanent healthcare standard? I think that's one thing we need to really think about as a realistic possibility. For the permanent general industry standard, though, what will that look like? We know it's not going to look like the ETS, the Vax-or-Test ETS, because the court has already said you can't do that. Will it have a narrower application? Will it be listed? Will it look like what we saw, Vax or test, and wear face masks for the unvaccinated, but not apply across the board, apply only to those high hazard industries that even Justice Comey Barrett recognized in oral argument may be implicated and may have a unique COVID hazard in their workplace. So we should look at the NEEP industries, we should look at the Vaccinate-or-Test ETS, we should merge those together and ask ourselves, will that be what ultimately comes out of this rulemaking? That's a real possibility. A second real possibility, I suppose, is changing the scope of the Vax-or-Test proposed rule and making it not a Vax-or-Test proposed rule, but really aligning it much more with the programmatic guidance that exists right now on the books, right? OSHA's guidance, all the things we've talked about, barriers, distancing, programs, disinfecting, all those components. This is the part of the story where we say, be careful what you asked for, right? I mean, a lot of people were very concerned about the Vax-or-Test ETS, and certainly about it becoming a final rule. But what did we replace it with? OSHA does seem to have authority to do these sorts of programmatic rules. And in fact, as I understand it, there are a lot of forces, sort of institutional OSHA forces, that were pushing from the get-go to have the COVID general industry rule look like the guidance looks, look like the healthcare ETS. It was really the White House and the Department of Labor, I think, that was pressing for this Vax-or-Test ETS that ultimately now cannot be. So big questions abound. This question about logical outgrowth. Can OSHA take this existing rulemaking where a proposed rule has already been issued and comments have already been received? So there's no need theoretically for additional comments. But if they work that rule so much to not really look like what the proposal looked like, there's a real possibility that there could be a challenge along the doctrine, based on this doctrine of logical outgrowth, which says basically that the final rule has to be a logical outgrowth of the proposed rule. Otherwise, commenters really, it would be meaningless comment, right? They'd comment on something that they really wouldn't have gotten to comment on the components of the final rule. So
one last thing, Kate, these are the two rules you're talking about, the healthcare COVID-19 rule and the Vaccinate-or-Test COVID-19 rule. There's a third rulemaking that is on OSHA's agenda right now, which is the broader infectious disease rule, which is not limited to COVID-19. Do you have any just quick thoughts about that and how that intersects with this discussion?
Yeah, absolutely. And I'm glad you brought that up, because I was thinking about that earlier and I forgot to mention it. To my mind, a broad COVID programmatic rule, not the rule that was challenged and successfully in the Supreme Court. A broad rule for COVID, I think looks an awful lot like what a general infectious disease standard would look like, right? COVID is a virus that is very contagious. And that's what the infectious disease standard would be designed to control, the hazard of transmission of an infectious virus in the workplace. So OSHA could, instead of dealing with this logical outgrowth problem by trying to cram a square peg into a round hole by changing the Vax-and-Test rulemaking into a programmatic infectious disease standard rulemaking, they could just pivot and use the rulemaking process that they have already begun for the infectious disease standard and write a standard that deals with not only COVID, but any next virus that might surface. And so, to maybe really get into the rest of our webinar, one of the questions we want to ask you or have you as employers think about is, how can you effectively protect your workers from infectious disease? I mean, surely we all want to do that for a myriad of reasons, the most important of which is the health of our workers, but also secondarily, the production and efficiencies of your workplaces, right? When people are out with infectious disease and it's being transmitted in the workplace, it's a disaster from an operational standpoint. So we all have an interest in protecting against the spread of infectious disease in the workplace. It is not a bad thing, I don't think, to have a reasonable rule that is designed that sets guardrails around what the employer ought to do in that regard. So be thinking about that, because we have a lot of lessons learned. You all have a lot of lessons learned about what worked, what didn't, what was disastrous, what wasn't. And so, you know, before even OSHA gets to a rulemaking, we ought to think about how to protect our workers on a voluntary basis from infectious disease.
Hi, this is Amanda Walker, and Kate's been talking about some of the rulemakings and trying to determine where OSHA is going to go with COVID next, COVID-19 enforcement, and addressing the health hazards. And one of the other things that we look at is enforcement. And unfortunately, in most cases, it's usually 6 months behind, or before we get to see the citations that are coming out of the agency, there's a 6-month lag, which is quite a lengthy time period in dealing with COVID-19. But interestingly enough, there was one set of citations that was issued one day after the Supreme Court ruling came down. So this was in the works for a while. And the underlying allegations go back to August, where a manufacturing facility had about 12% of its workforce test positive for COVID over 2 weeks in August. And so OSHA went in and conducted inspections. There was a number of hospitalizations, and I think ultimately 2 of the employees did pass away. So there would have been some reporting obligations to OSHA, and OSHA came in and did an inspection under presumably its NEP enforcement for COVID NEP. And they issued a general duty clause violation for factors, or what they saw as not addressing the hazards in the workplace. And it was primarily for not enforcing the policy that was in place, which had to do with masking when you could not keep a safe distance of 6 feet or more, and also not keeping those distances. I think there was some areas where the individuals or the company, there was a gathering of some sort where individuals were closer than 6 feet together without masks on, and could have been the source of the outbreak or resulted in a large number of transmissions in that 2-week period. OSHA came in, issued a general duty clause violation, and had a number of things to say, that they could have done to abate the hazard. Update the plan. The plan that they were operating under was one that dated back to early in the pandemic, sometime in 2020. So update the plan. If you have a plan in place and it's going to be requiring masking or social distancing, making sure that it's being enforced. They also said that if you are going to update your plan, and it seemed to suggest that you should, depending on the dynamic of where you are in the pandemic, you also need to train your employees on those updated changes. Another component that OSHA said was contact tracing. I'm not sure that this employer did employ contact tracing techniques to try to determine if these cases were initially characterized as work-related. Screening employees and having a mechanism in place for employees that show up at work who are ill or not feeling well, so you can segregate them away from the rest of the employee population so that you can minimize transmissions. Follow up and implementing the good, safety practices, hygiene, cleaning, all of those, and just making sure that you were following the plan that you had developed. And one of the last ones, number 7, I thought was particularly interesting, was facilitate vaccination by granting paid time off for employees to help get them into the clinics to get the vaccinations and get their 2, 3, whatever it may be. One of the other things that we thought was particularly telling was follow and implement guidelines from the CDC. They're referring to the CDC guidelines here in the state and municipal public health recommendations, which are a Mod Podge across the country. So we thought this was interesting, but we also have to keep in mind that this was in August. This underlying event occurred in August of 2021. We are moving through this pandemic, and that seems to be eons ago. I don't even know that maybe the Delta variation had started at that time, but we certainly hadn't seen Omicron. So now it might be a little different, but certainly a little telling what OSHA would be expecting employers to have in place, especially in the manufacturing setting.
Thanks. So thanks, Amanda and Kate and Aaron for the background. And I think we've been trying to address some questions that come in through the chat box throughout. But now I thought we'd just kind of open it up for some discussion here with some questions that we have. And if you all have more questions that come in, we'll sort of use that to kind of trigger a panel discussion here with Kate and Aaron and Amanda and Beta and me. I mean, the number one question that I think is on everybody's mind is what should employers do now, right? Tomorrow, what is my policy about face coverings? What is my policy about masks? Do I distinguish between vaccinated and unvaccinated? Does it matter where in the country I am? Those are the kinds of questions we're getting every day. Not great or easy answers to any of that, but I just want to open it up to my partners and my colleagues to hear your thoughts about that. Is there regulatory risk for employers to say, we are now moving to a mask encouraged policy? Masks are not required, regardless of vaccination status. We've got them, we'll supply them, we encourage you to wear them, but they're not required. Can you be cited for OSHA for implementing that policy tomorrow? And nobody, I'm sure, wants to volunteer to tackle that unanswerable question. But on my screen, Aaron is sitting at the top. You want to take the first crack at it?
Sure. I got a similar question yesterday here in Illinois from an association that I work with. And I think, after Governor Pritzker here in Illinois announced that he's going to, I believe, lifting the statewide mask mandate effective the end of this month, end of February, for essentially all indoor spaces, except for, I believe, like schools and transportation hubs and things like that. So I think I often will analyze this issue kind of a hierarchy of risk. And I think if you're in a jurisdiction, whether it's a county, a city, a state, where there is a mask mandate, so your local governmental body is requiring masks, and you depart from that, so you're essentially violating local either state or local law or orders. I think you absolutely 100% have a pretty high risk that OSHA would like cite you if they end up in your workplace, right? Somebody passes away, somebody makes a complaint. I think from a practical standpoint, I have seen very few inspections that are opened simply in response to complaints. But certainly, and I think the citation that Amanda just reviewed, right? If you've got a major outbreak situation, and OSHA's, I think, very likely to open an inspection, especially if somebody dies, and if they find out that you're particularly in a jurisdiction that requires masks and you're not enforcing them or you're not requiring them, I think the risk of an enforcement action is pretty high. Fast forward to central downstate Illinois, March 15th, the governor has lifted the mask mandate at that point. I would say, again, it depends. I'd like to know what the county transmission rates are. I think if you're in a county with like low to medium transmission rates at that point, and you're consistent with prior CDC guidance, or was consistent now with CDC guidance, which I think still would say that you can at least stop masking the unvaccinated or the vaccinated. I think it's pretty low, but I think unless and until the CDC changes its guidance that kind of departs from masking, I think you're still going to have. I couldn't say that you're not going to have some risk.
Let me ask you, Kate, is the administration sending any signals that would suggest this approach to sort of looking at what's happening at the state level, looking at what your governor's saying about it, looking at sort of more of a local level review? Are you seeing anything that would give a defense lawyer some extra backing to defend an OSHA allegation that you abandoned masks here in Florida, or in Texas or somewhere where the governor, or in Illinois as of some point in March, when the governors have lifted mask mandates and the county or state health departments are saying something different. We look at these citations like the one that Amanda reviewed that talked about CDC guidance. Is there anything that tells us that this sort of more local approach may be acceptable to OSHA right now?
Yeah, Eric, I mean, yes, there is. A couple of, I think, nothing official, but a couple of really interesting statements have been made by this administration, high-level COVID officials, Dr. Fauci, who's very well respected, and very conservative in terms of his approach to COVID, and Dr. Walensky, the head of the CDC. Both in the last week have made statements that indicate that, well, certainly no one's coming off follow the CDC guidance, right? But they're also making statements that we had not heard over the last year since Biden's been president, that basically say, listen, we're moving, things are changing on the ground, and we're moving from a more nationalized response, which was necessary at the height of what we've been dealing with, to a more localized response. And we're moving, this is going to become someday an endemic, not a pandemic. And we're hearing that from a lot of sources. So I think, and this sort of addresses what Aaron was saying as well, I just caution a little patience. I think we're almost there. I would not advise any of our clients at this point to say, game over, victory declared, and take your masks off. To put those plans in the trash. I think they're still important to keep in place for at least a little while longer, to the extent you can. And I know, trust me, we hear every day, every hour, how employees are complaining about masking, the concerns about safety in the workplace when you're wearing masks. There are lots of challenges, but I think we're moving in the direction, and even this Democratic administration is moving in the direction of saying this is going to be regulated on a local level based on local guidance and or authority from the health department, as opposed to from on high, from the Department of Labor. I also think, from what believe about the OSHA folks, the OSHA people are as sick of this COVID pandemic as the rest of us. And they really have a lot of important work to do, I think, that they've identified as priority work. So I think they would like to move away from a very hot political controversial issue and get back to the bread and butter of what they do. Now, they're not going to walk away from COVID. The problem that employers have, I think, is it's, for the time being, it's going to be a results-oriented approach where the entities that maybe through no fault of their own end up having a number of hospitalizations or deaths at the workplace, those entities are going to be the ones that OSHA is going to scrutinize carefully still under the general duty clause. And if you're not in compliance with all the pieces, or at least the major pieces of what OSHA has identified as important and the CDC has identified as important, I think there's real legal exposure there.
Let me ask the question this way. Remembering that we had an emergency standard, the vaccination, testing, and face coverings emergency standard, that required face coverings only for unvaccinated workers, that did not require quarantine for close contact at all, that didn't require distancing at all, that didn't require disinfection and cleaning. This was one of these, you talked about the careful what you wish for situation. The weekly testing was going to be absolutely brutal, especially the way OSHA set it up with that no self-read, self-administered test. But otherwise, that rule relaxed a lot of the requirements that right now we can't give you a clear answer, don't exist. What do you all think? Anybody that wants to volunteer to talk about this, what do you all think about that masking for vaccinated workers right now? Do you think there's risk if you otherwise verified vaccination status, which a lot of people did already in preparation for, or not even in preparation, when the rule went into effect in December? If you know who's vaccinated and who's not, and you are taking steps to enforce it, does anybody feel like there's regulatory risk in dropping the mask requirement for fully vaccinated workers today?
Happy to speak up on this. This is Amanda, and I
Yeah.
would say that yes, I feel as though there's some risk for taking those masks off the vaccinated employees, especially working indoors closer where you're not able to maintain a 6-foot distance. I think that's probably different for employees working outside, even if you have some minimal contacts, but for employees that are indoors and within 6 feet of coworkers, regardless of their vaccination status, I would still encourage employers to keep them in masks. I think that's what OSHA would expect. I do say that's a snapshot of the answer today. I don't know. I think it's going to be a moving target, hopefully in the next month, as we see CDC come out with some clearer guidance. One of the other sources that we looked at earlier today was the federal government's policy on entering federal buildings. They still have their masking requirements pretty much intact or similar to that. So kind of keeping an eye on CDC and also what the federal government's doing with their workforce should be indicative. And I think that it's likely to change in the next couple of weeks, month.
I mean, I would add, I think I agree with Amanda. Obviously there's risk. And I think a lot of it's going to depend on what compliance officer shows up to do the inspection, which assistant area director is managing it, which area director has it, right? I mean, it's going to vary based on, I mean, we've all had
which
inspections.
OSHA lawyer you have representing you.
Fair enough. But right, we've all had compliance officers who share their personal views with us about all aspects of this, that some of them don't like the vaccine mandate, other ones that don't think the pandemic's exaggerated. You get that person, obviously the risk is pretty low. You get someone else, the risk could be higher. But I mean, I think beyond that, and just judging from some of the questions that we've been getting in the chat, I mean, there are, and I think a couple of you have said this already, a lot of people are pretty much done with this. And so if there's an employer out there that wants to push the envelope a little bit, I think, Eric, as you outlined, I mean, if you are generally complying with the framework of the now defunct ETS, and you assembled your log or your roster, you've ascertained vaccination status, you're still maybe paying people to get, for time spent getting vaccinated, and you're generally complying with that ETS, I think it'd make for a really interesting discussion at an informal settlement conference or with a solicitor who's, they're going to come in there and devote their resources to making an example out of an employer that's generally complied with the ETS that they just promulgated. I think that would be interesting.
No.
Especially because they didn't withdraw the proposed rule. There is a proposed rule in the Federal Register that says masking for fully vaccinated workers is not required. Now, I think the point you were making was that's in the context of other broader protections. And that's the weak link here, is that if you're not doing weekly testing, which I assume, I don't want to assume nobody's doing it, but practically nobody is doing the weekly testing. Maybe you're incentivizing vaccination, maybe you're tracking who's vaccinated, who's not, but there's certainly some risk in saying, well, you didn't require face coverings for vaccinated workers, so we're following that. Well, the reason why they weren't requiring that was because they had these other protections like weekly testing and so forth. So I agree, there's still some risk doing it. This is the careful what you wish for situation. We went back to masking a group of people we didn't have to mask before because that rule has been thrown in the trash. But I like the idea, and I think I would certainly defend this vigorously, that look, we know who's vaccinated and who's not. We're enforcing it only for the unvaccinated workers. And you said that was acceptable a few months ago. It's still proposed. That ought to be enough. I would feel, I'd feel comfortable defending in that situation, but you may be in a position where you are defending, which is less than ideal.
And let me add a couple of things based on discussions I've had with a lot of companies out there. I think a lot of folks are not tracking and never did really get a good handle on who was vaccinated and not. And that is itself a very controversial thing. So I don't know that the large part of America already has that down and could rely on it. Right. So, so the question is, should your guys out in the, not in the field they don't have to be masked, but in the warehouse, in the grocery store, in the retail setting, in the manufacturing shop, should they be wearing a mask or not? One of the things that I think I don't think OSHA's going heavy on enforcement. It doesn't look that way. Now, we've only had a month since the Supreme Court decision when, Marty Walsh came out and said, we've got the GDC and we're going to hold you guys accountable. But we've had all of one citation under the general duty clause. And that was the one Amanda talked about that was issued the day after. It was not a Supreme Court decision driven enforcement action. So we're not seeing so far a lot of enforcement actions. I don't think overall, by and large, OSHA is going to be out there with aggressive enforcement for companies that don't have their employees in masks. But the problem right now is, and this is why there is regulatory risk, if it happens, if you're the unlucky, facility that somebody walks in with COVID and it spreads like wildfire because no one is in masks and there's no distancing and, basically the other protocols are dropped. You're going to get an inspection, and that's where I think you're going to get caught. And so what do? It's a real quandary right now. I do think that's why I think patience is a virtue. Give it another month. Keep those guys, if you can, in masks. I think the CDC is going to go with the wind. Not to disrespect the CDC, but I think there is some level of political policy decision-making that is going to be driven by something other than the pure science. Plus, the pure science is moving in the right direction, right? The cases are going down. I think by May, we're going to be probably where we felt we were last May, right? Like, okay, it's feeling good. We're going to restaurants. We're stepping out a little bit. And then we got hit. So anyway, but the one thing, Eric, that you and I were talking about before this webinar, which is of all the things that we think you really must continue, that is isolation of COVID cases, right? If you've got a worker in the workplace who you learn has COVID, we really think you need to get them out of the workplace. You need to do it pronto, and you need to follow the CDC guidance, which is now only 5 days, I believe. Beta can correct me if I'm wrong there, but without symptoms. And if you don't do that, I can almost guarantee if OSHA's in your place, hire us now, because you're going to get it. You're going to get a citation.
Yeah, that's the point that I was about to make, was that, there's obviously a huge focus on masks, right? Face coverings has been, it's sort of the symbol of the administrative controls or engineering controls, but I'd call it an administrative control. And so that's where everybody's attention is. But the point you just made, I think, is incredibly important. Almost every citation that we've seen under the general duty clause has had at its core the response to positive cases, right? The notices to coworkers, isolation and removal, isolation for sick, infected individuals, quarantine for close contacts. To me, no matter what other policy you have, whether you abandon masks, whether you abandon distancing, and I think most people have abandoned, your cleaning and disinfection, except in pretty extreme circumstances, whether you stop doing pre-work health screenings or symptom screenings, isolation of infected individuals, to me, should be the very last thing to go. You need to continue to take steps when you are aware of a positive case to have that person out of the workplace. That you're going to continue to see enforcement of that issue. But let me ask, on the other side of that coin, do you all feel the same way about quarantine for close contacts, as I think we all agree about isolation for confirmed positive cases? Is that something where we need to continue to identify close contacts and have them remove themselves from the workplace for some period of time? Or are we at the stage now where it is only about isolating COVID positive cases? What do you think from an enforcement standpoint there?
I think vaccination plays a huge factor into the answer. Off the top of my head, I don't know what the current CDC guidance is on that, but I would certainly follow that closely.
Yeah, my personal view is that there is very high regulatory risk in not isolating a confirmed positive case, much lower, but not immaterial regulatory risk in not quarantining close contacts. And again, this was in the ETS that is now in the trash bin That was not required. But I think with that rule going in the trash bin, there is at least some regulatory risk in not following the CDC's current quarantine guidelines. So
And I think it's also tied in with amongst the feasible means of controlling it in the citation that Amanda discussed. I think you referenced it too, Eric, like notifying people of when they've been exposed, and what sort of symptom screening. And typically now, I think almost everybody is defaulted to self-screening.
well, yeah.
But I think if you look at take all those together, that I think if an employer is not notifying the people who have had a close contact, not doing contact tracing, not requiring employees to self-screen, maybe requiring those people who have had a close contact, who, if they're still coming to work, assuming they're vaccinated, to wear a mask for that period of time. I think the less you're doing, the greater the risk, right? If you have a program in place, I know it was next to impossible during the Omicron surge, pretty much for almost everyone we spoke to, but now as we revert back to, I think, the new normal, if you're not doing any of those things and you know that someone was positive in the workplace or during their highly infectious period, obviously if you notify the people that they were exposed to, you make sure that there's symptom screening, you have them in masks, I think the risk is low. If you're doing none of those things, I think it's high.
Yeah. So we're over time here, but there's a couple more questions I want to ask, and I understand if people want to drop off, but this is what we do all day anyway. We sit around and talk about this, so you're just getting to kind of watch, what our ordinary day has been like the last 2 years. I've got two other topics I want to get y'all's opinion about. One is the state plans. We talked about how the state plans aren't required to, and apparently are not going to adopt a vaccine related ETS, but there are some state plans that still have existing COVID-19 regulations. Does anybody have just can recount for us off the top of their head what states have those rules, and what do we think about enforcement in those states? I mean, I think that's an easier question, but don't lose sight of the fact that, well, if OSHA is backing down and the CDC is backing down and all this hunky-dory, there are regulations that exist out there that unless or until they go in the waste bin, you got to comply with them. Who's got active COVID-19 rules now, Bita?
Yeah, so, and Eric, that's where I was going to just circle back to the face covering piece, because off the top of my head, Oregon, California, Virginia come to mind as sort of having those, top to bottom kind of programmatic COVID-19 rules. And, in particular with California, and California is, face coverings required for unvaccinated. But there is a caveat there, like unless, otherwise ordered by the California Department of Public Health. So, California has been under this, statewide, everybody's wearing masks. But as they do the face covering requirement, which it sounds like that's the way California is going, still be careful of jurisdictions that are deciding not to follow the state guidance. I think Los Angeles and Santa Clara have already declared that they're going to keep their mask mandates in place. And then also with Virginia is a really interesting one with the sort of new politics there, but yeah, I believe on Monday actually the safety board met. And this was in response to the governor's executive order. He directed them to meet to actually, kind of decide whether the standard is needed anymore. I think
I think that meeting got pushed to next week, so we don't know the outcome yet.
Right.
But, right. You have a transition from a Democratic governor to a Republican governor whose, big part of his campaign was, easing COVID restrictions. Has made it very clear early on that's his intention. And so right now, Virginia has a permanent COVID-19 rule, but the governor has, I think, signaled pretty clearly he intends for his Virginia Occupational Safety and Health Agency to address that. But until they do, it's the rule, and you've got to comply with that rule. And that does cover face coverings and other engineering administrative controls. Oregon has its own set of rules that I think also address some of those key issues So really, those state plans, you got to pay attention to where they are, because that's not as easy as making a business judgment about how much risk you want to take. There, it's kind of black and white, right?
That's right, Eric. Yeah, and Oregon's is a little. It actually follows Oregon Health Authority, the face covering piece at least. So at least there's consistency there, and I think they issued a statement that they'll be revisiting their guidance, their rule in the next coming weeks.
All right. The last subject that I want to cover, and then I'll let, if you guys have stuff you wanted to raise as well. The last subject I want to cover is COVID-19 record keeping. And I didn't suggest to you all that we'd be talking about this, but I saw a great question from a respected client of ours in the chat on this issue. And it's certainly an issue that we've been grappling with in great detail, especially during the Omicron surge, is what is the current landscape for employers in COVID-19 record keeping, and what should employers be doing in that context, especially as you have now on your desk, no doubt, a pile of employees who have reported a COVID positive test during the Omicron surge. Highly unlikely that could be attributed or determined to be attributable to the workplace, but what are employers supposed to do about COVID-19 record keeping right now? And what are we trying to do about that as a firm?
Well, I could speak to the latter point just a bit. One of the things that I think we have consistently advocated to this agency, to no effect so far, is that the record keeping analysis, traditional record keeping analysis for work relatedness, really does not and ought not apply to COVID-19. The whole purpose of keeping a log is so that you can do trends analysis, so you can know where the hazards are. Those kinds of objectives don't apply to a pandemic type virus like this. I'm, an advocate for very safe workplaces. I think OSHA does a lot of good things, but I think they got it just dead wrong on making employers continue to follow this sort of traditional work-related analysis for COVID. I think employers would be better off if we could just, I don't mind, I don't know how you guys feel out there in the audience, but I think I wouldn't mind seeing a rule where you had to just keep a COVID log. It wasn't work-related. It wasn't not work-related. It was just, okay, these guys got COVID. In the healthcare industry, CMS requires that sort of reporting to CMS. So a COVID log, but not, and that COVID log could be used by you guys to do, contact tracing if that were necessary, but not putting those names on your log that then indicate that, there was a failure on your part and there's some real life consequences associated with DART rates going up and workers' comp insurance premiums rising, and a whole slew of things that are really bothersome and really, for a situation like this, for the most part, do not apply. That doesn't mean that there isn't the employer out there who's really not doing a good job, and they could have controlled and didn't the spread of COVID, and those are work related. And so OSHA would miss those on the log, and maybe rightly they should be, but that's the aberration, not the norm. And so anyway, that's been our effort. I think it would continue to be our effort in any sort of permanent rulemaking. Yeah, that's my.
But as it stands today, what do you understand OSHA's expectations are about evaluating work relatedness and logging COVID cases that somehow are determined to be more likely than not work related? Amanda, I know you got into that issue in some detail. What do you think OSHA's expectations are today?
With regards to the work-related analysis?
Yeah, I mean, what's expected from COVID? What's expected from 1904 injury and illness record keeping in terms of COVID cases?
I think a close evaluation on what the employee's job duties were, who they were in contact with, checking to see if there was a possible transmission in the workplace, and if it's documented, all the better. I certainly think that OSHA expects that work-related analysis to be taking place at this point, especially even with, thousands of cases that we saw with Omicron, and individuals were just so overwhelmed. The number of cases they were dealing with went exponential growth in a month from what they had been dealing with from earlier in the year. But OSHA has not provided any relief on that front.
And so the expectation is it's a case-by-case review
Yes.
for every employee you learn of who's tested positive, and in analyzing whether the case is more likely than not work-related. Do we still think that that wonderful caveat that has been around in OSHA guidance from the beginning is still there? That if there is any credible non-work exposure that is identified by the employee or the employer, that wipes out a finding of work-relatedness? Even if it's, I spent 8 hours at work 5 feet away from a coworker who it turned out was positive, but I also was at a dinner party where there was a COVID positive person present. That's a non-work related case based on OSHA's guidance, do you all think?
I know
When were they, I think you have to look at, I think we were getting better with the science with regards to when transmissions and, supposedly people are infectious 2 days prior to symptoms. I think, trying to game it out. It's very fact intensive.
And Kate, I know we've worked really closely on this too, but I'd say, just one caveat to that is just not, having that identifiable, that other source, right? Not letting that be generalized. So saying that, oh, the employee went to a grocery store, so therefore that's an alternative source of exposure. I don't think OSHA will go for that. But if you do find party situation and there was a COVID-19 case, I think that would, it seems like, I don't know if you agree, Kate, but I think we've, talked to solicitors in the past who've said, yeah, I think that would pass muster.
So an identifiable contact, an identifiable exposure to an infected individual outside of work would eliminate a finding of work-relatedness, no matter how sort of in your face the workplace exposure is. I think that's right. The other issue though, and this is I agree with you, first of all, that you need that identifiable exposure. And that had been sort of OSHA's views of this through the pandemic. But during Omicron, I feel like they're wrong. I mean, there just needs to be some recognition that exposures happen everywhere. I mean, it was, we talked about it being ubiquitous throughout the pandemic. It was truly ubiquitous from, December to the present. I think that there ought to be some recognition of that in your work-relatedness analysis, that maybe going to the grocery store ought to be enough without an identifiable exposure. OSHA has never gone that far, but during Omicron, it might be a judgment that is a risk that's slightly more tolerable to employers to say this was everywhere, and so I'm going to reach that kind of conclusion. But OSHA they haven't changed their guidance because of a surge like that. I don't know. Anybody have any other thoughts on that?
No, I think it kind of harkens back to we all in this preparation for this webinar, when we were talking about some of the discussions we've had, be the references with solicitors. I mean, I think I told you all, I'd talked to a solicitor who shall remain nameless and no reference to the region, but I got the definite impression that they are pretty much, they really don't want to see any more of these cases. So I would think that the appetite to litigate a record keeping case when they're, especially about an Omicron transmission, again, no guarantee that you're not going to get caught with a citation, but I just think I agree with you. I mean, there was that, I know one of the early reported cases of Omicron where they believed it was transmitted across the hallway of a hotel when people were quarantined from traveling, and the only contact the person had was opening the door in the same hallway as someone who was apparently infectious. So if it truly was that transmissible, yeah, how could you rule out, going to the grocery store or being out and about?
We'll prevail on that with the B2 variant.
Right. Eventually, right. I would say this, though, I think it's a slightly different risk assessment from a reporting standpoint. In other words, those COVID cases that result in death or hospitalization, although
Yes.
hospitalization, we should generally be fairly safe from reporting obligations again. I think, yes, except in healthcare, but not to go down too deep of a rabbit hole. But if you have an employee who succumbs to the illness, I think it is worth doing a very careful work relatedness assessment. And if you determine that there is an identifiable exposure at work and you can't identify a identifiable exposure away from work, I think there's much greater risk of a violation for not reporting in that circumstance than there is in any recording determination that you make. But I do think you probably want to be able to show that you are doing something in the way of a work relatedness assessment. And if it means that you're doing it outside of that calendar week, which I know is almost certain to be the case for some national employers who are dealing with thousands of cases during Omicron, I do think you still want to be able to demonstrate you've taken some effort to evaluate work relatedness, even if it's a more superficial one now than earlier in the pandemic. But that's we'll let you all go. We'll probably continue to have these kinds of discussions and debates over the rest of the day. But I really appreciate everybody joining us for this discussion. I'm hopeful that we are not going to be having our regular COVID-19 related webinars for you, and then we'll get back to talking about other interesting stuff like heat illness and other, the more traditional OSHA issues. But we do still have our COVID-19 task force resource page up. We are continuing to update that over time as the landscape changes. I encourage everybody to check that out. And I encourage everyone to join us for the rest of the webinars in our 2022 webinar series, which I'm just double checking does not include explicitly any more COVID-19 discussions. So I'm thankful for that, although we'll probably sneak another one in there when some big development occurs on that front. But you can see that. I encourage everybody to sign up and join us for that, and to check out our blog to sign up and register for that, so you get by email the updates that we put on there. We've tried really hard, especially over the last 2 years, to make that a valuable resource for everybody. We try to update things quickly, and not just to say this thing happened, but to say here's why this is important, here's how it affects you. So I encourage everybody to check out the OSHA Defense Report, the Employer Defense Report, and our Cal OSHA Defense Report as well. And thank everybody for joining us, and we look forward to seeing you next time.